So without further ado, I am going to turn it over to our two panelists today. First, I'm going to introduce Allison Hertz from Kaye Bender Rembaum, one of our attorneys and a board certified specialist in condominium and planned development law. And joining us today as well is Brendan Lynch, and he is the president over at Plastridge Insurance. Allison, please take it away, and let's go over how we're going to handle questions.
Hi, everyone. Thank you very much, Jeff. Thank you, Brendan, for being here. Just quickly, once again, I'm Allison Hertz, attorney here in Palm Beach Gardens office of Kaye Bender Rembaum. We are a community association law firm. All of you know that. Hopefully you've seen some of our recent presentations on other various topics. Excited to be here today to talk about association insurance, hot topics for 2021, some topics that are always hot topics, and happy to have my partner here, Brendan Lynch, co-presenter of Plastridge Insurance. We've known each other quite a while, and of course, premier insurance company serving all of our associations. Brendan, say hi to everyone.
Thanks, Allison. Great to be here and to go over these topics.
Very good. Well, we'll jump into the presentation at this point. We do have a mini PowerPoint just to sort of keep us on track here today. We're trying to talk about several issues that are emerging, that are here right now, and we want to take questions during the presentation. I do like to do that, but as Jeff Solomon mentioned, we are going to try to keep them on topic today as to association insurance. And I've broken out the PowerPoint into several subtopics, and we'll talk about the subtopic, and then hopefully we can take some questions related to that subtopic and move forward as to the other one. And if we have time at the end of the presentation today, maybe we can take some other questions that we didn't have the chance to, or other types of topics that maybe we didn't get into in detail today, but you have concerns regarding. So I'm going to do a little share screen right now and get the PowerPoint going. Do you see the PowerPoint there?
Yes.
You do, yes.
Now you don't, huh?
Hey, Allison, I just wanted to point out one of the participants had mentioned there's an echo, and I'm not sure if maybe they're logged in on their phone and computer. That'll often happen. Just for the group, if you have your phone, you have to disable your computer connection or you'll get that feedback.
Yeah, I heard a slight echo right at the beginning, but thankfully then it went away quite quickly. I'm not sure if anybody else is experiencing that. If you are, I guess Tina had commented, if anybody else is, just let us know in the question answer and we'll try to deal with it. But okay, we'll go forward at this point because we have a lot of interesting things to discuss today. Association insurance, hot topics for this year, jumping right into it. The first topic, is it moving along? I'm a little, can you see the volunteers on the screen?
Nope, not yet.
Not yet.
Technical difficulty, I'm sorry. All right, I need to
This always happens. It works when you try it, and then when you go live, it...
yeah, I'm sorry. We'll get it going. We do this all the time.
Hey, Jeff, there was a comment here that somebody's chat was disabled, but they can see the question and answers. I'm not sure if that's...
Yeah, chat is disabled. For those of you who came in a little bit late while Allison tends to the technical difficulties, chat and raise hand is disabled. It gets a little chaotic when you have a bunch of chats going on, hard to keep track of. So we are using the Q&A icon at the bottom, and that's how you'll be asking your questions today.
Perfect. Thank you.
Okay, I think we're there. Are we there, volunteers?
That's perfect.
Yes.
Okay, great. Okay, we're all back together. Okay, so back to association insurance and not, IT world here. We're here to talk about association insurance. The first topic that sort of came to mind for this year, which is really off of last year, was volunteers. Volunteers, had come up last year and into this year because of the local orders coming down, particularly here in Palm Beach and Broward and Miami-Dade, that required a lot of monitoring due to COVID protocols, pool monitoring, gym monitoring, different types of monitoring. So as to, hot topics, we did see a lot of inquiries concerning, how do we deal with volunteers? In addition to sort of the COVID related volunteers, we always did have questions concerning, people in the community who want to help with landscaping, people in the community who want to help with sort of construction type services, and board members also, who also want to help either perform work or, change a light bulb or fix a toilet, something that they're able to do. So in terms of volunteers, we did see this recently with COVID, but it's sort of always been there. And clients frequently ask me, and I know that they ask you, Brendan, whether there's a workers' compensation, coverage for this type of activity on the property out, whether it's by general community members or by board members directly. Do they qualify for workers' compensation? And what are the suggested ways to deal with that, short of release and waiver forms, which we can talk about, afterwards? What are your suggestions? Because I know you get that question very frequently.
We do. And, it is a good question. So when it comes to, there's a couple of thoughts here. When it comes to workers' comp and volunteers, not every company that provides workers' compensation includes an endorsement that provides coverage to volunteers, which is really important. Now, keep in mind, every association needs workers' comp, even if they are with a management company. The good news is if you're with a management company, there's a policy out there called a if any policy that's a workers' comp policy, and the premium's only $610 a year. It's very inexpensive. What that does is it gives you coverage for exactly things like this. It does cover, if you're with the right company and you have the endorsement, you'll have volunteer coverage, but also it gives you coverage if one of your vendors that you're hiring either doesn't continue their own coverage and one of their employees gets hurt and they try to bring a action against the association. So for $610, it's incredibly valuable coverage for those two reasons. The other reason that it's important is because while the directors and officers liability does cover committee members that are volunteering, as long as the committee is sanctioned by the board, there's an issue with workers' comp policies having an absolute exclusion for any kind of virus related situation. So when this came up last year with having the pools monitored, et cetera, the problem would be volunteers are covered, but the policy on the directors and officers has that exclusion. So, and generally there's also an exclusion on the general liability. So basically the only place that you could look for coverage if something happened would be under the workers' comp, as long as you have that endorsement for volunteers.
The if any endorsement is what you're talking about, right?
So the if any policy is actually for associations that are managed by a management company. They don't technically have employees.
Okay.
But that $610 if any policy can also cover volunteers. So it's but your regular, if you have a self-managed building that has a regular workers' comp policy with their own employees, that policy can also have the volunteer endorsement.
Okay, so let's go over this in sort of like a category. If you're an association with a management company, the management company should have their own workers' compensation policy for their own employees.
Correct.
If you're an association who has a manager and maintenance employees and lots of employees and direct personnel, you need to have your own workers' compensation policy. That's for sure, right? If you have if you have volunteers who are outside of board sanctioned committees and all of this stuff, you need that other policy is the suggested way to go. Is that an accurate summary from your perspective, Brendan?
So just on everything, yes. The last piece on there, when you have non-sanctioned committees, is a tricky one. We try to avoid that. We would prefer to see that the board has approved a decorating committee, an event committee, whatever the committee is. Even if it's a landscape committee, it's much cleaner to have that sanctioned by the board.
And if they're not in the committee, they're just a straight volunteer,
right?
Then That's
Then,
when.
right. The workers' comp will, as long as you have the right endorsement, you would cover that person if they were injured.
Okay. So there seems to be a lot of available coverage here. It's just sort of getting to the right product that fits the box for the association and
Right.
thinking about, how your operation is being run. Do you have employees? Do you not have employees? Volunteers? Are they really committee members or are they not committee members? So depending on sort of the hats that these people are wearing, there seems to be quite a lot of coverage out there available, and not for a very substantial amount.
Right, and they don't actually overlap. I want to be clear in that, they do. It's all based on what happened and who got hurt, right? So, and on the other, there's another coverage called an accidental death and dismemberment policy, which I don't like the name, but that is the name, and
A scary name, yes.
It's right. It's specifically, called an accident policy, and you can buy this policy, and it's sort of a catch-all for anyone that might be working on the property. The problem is there are very low limits of coverage, $10,000. So it's not necessarily, going to do that much, but it is a policy, and it's, $300 a year, but it gives you like a nominal amount to help if one of the volunteers does get hurt.
All right, just to answer, I think we've already answered this, but John had a question. If our association has no employees, do we need workers' comp to cover any volunteer work and or engaged contractors? And apparently the answer is yes, as long as you have the proper endorsements, you should be good there. And that gets us to the last point. Last year, earlier this year, when we talked about COVID, all these volunteer policies, our concern was liability for the association, as it always is. If for those of you who were not aware, we did send out a blast on this, I believe, through our law firm, that Senate Bill 72, the immunity from COVID liability related claims, it's a pending bill up there in Tallahassee, was approved and signed into law March 29th, 2021. So, and it became a law upon being signed. It is effective right now. And this law now means that covered entities, including associations, will be exempt from COVID-19 related claims and lawsuits unless specific facts can be alleged that the association essentially committed gross negligence. So, we just talked about all of these policies that are going to cover your COVID volunteers, which we don't have that these days really anyway, because of all of the orders being rescinded, at least here in Palm Beach County and really through the state due to preemption. But we sort of took that slide backwards. At this point, the liability is sort of mitigated by this new statute. But as I mentioned, the volunteer issue has always been there. It's not really a hot topic as to this day, because we always had people wanting to help out with landscaping, and we always had people wanting to help out with construction projects. So despite the fact that we do have the COVID immunity bill that does affect associations, and if you haven't heard about this, this is something to be aware of. It does behoove you to go seek out this type of volunteer insurance for, to cover all the situations here if you have committee members or straight volunteers performing work on the property. Also, just because this COVID immunity bill was signed into law, that doesn't mean we all throw up our hands and, we throw COVID related concerns out the window, still dealing with masks, social distancing, sanitization. So of course I wanted to mention that as well. Brendan, you have any other follow-up, comments on volunteers before moving into our second topic here?
No, I think we've pretty well covered that.
Okay, I see some questions on the chat. Feel free to throw your questions out there. I didn't see any other ones specific to this topic, so we'll move right along to a very hot topic out there, very timely right now, subrogation. What is this all about? I think some of you might know this slide as the universal property and casualty slide. If you know that name, you know what this is. Just to briefly explain what it is before I sort of let Brendan jump in on a lot of the market issues and what's really going on here. I'll just explain that in the context of what we're talking about here today, we're talking about an owner's insurance company making a claim against the association, basically stepping into the shoes of the owner because the owner's insurance company had to pay out. And now they're coming back against the association and subrogating against the association saying, hey, we had to pay out and it's really your fault. So now you need to make us whole. And we've seen this, typically with the property damage claims, in that you will have an insurance company send you a letter demanding that you make them whole and pay them thousands of dollars for a payout that they had to provide to their owner. And this could be in the form of a demand letter. This could be in the form of a direct lawsuit. Just still go straight to a lawsuit. But we've received so many of these demands, lawsuits over the past 4 or 5 years, and it's really gotten out of hand. Obviously, it's caused increases in premiums for associations. This issue has been out there brewing for a long time now, and I see Brendan kind of smiling about it, sort of, because I know he's followed this issue that I have. And there is some pending legislation out there right now dealing with subrogation. But before we get to that, I want to have Brendan kind of tell us what his how he deals with these and what his comments are on why there are so many cases. How did this all develop? From an agent perspective, the clients are kind of jumping up and down. All these things are going up so much. What do you have to say about all of that?
Yes, so you're exactly right. This, anytime something of this nature makes it up to Tallahassee, it's become a big problem. It's no longer manageable if we have to legislate for it. So, I just want to be clear. There is a place for subrogation. When an insurance company, for example, there's one of my clients, an association, they had work done on a roof drain line. And a week later, we had a torrential rainstorm, and the elbow that was literally just replaced by a plumbing company became loose, and they had several inches of water throughout their entire lobby area and in their gym after they had spent around $100,000 just replacing the entire gym and all the equipment, which was completely ruined.
They must
that is exactly. That's a subrogation claim all day, every day. They're gonna go after the the insurance company paid the claim, and they're gonna pursue the plumbing company because it's clear that they did something wrong because that fitting should have held. So I wanted to just be clear that subrogation serves a purpose, right? So the insurance company is going to pursue what they paid out from the party that actually caused the problem. The issue that we're talking about is a completely different situation. We're talking about a unit owner's insurance company alleging that the building should have or could have done something different or better to prevent the damage. So another another claim that I have, a high pressure sprinkler line ruptured in a building in downtown West Palm, and there were 60 units damaged by water, and some of them very, very, high level damage. So we received, I think we're at 17 or 18 subrogation demands. Now, the purpose of subrogation is, again, somebody did something to cause damage. The insurance company is going to help their policyholder by paying the claim, and then they're going to pursue the people that caused the event to happen, right? This was a high pressure sprinkler line in the ceiling behind the drywall, and it split right down the pipe, not at a joint. There was nobody did anything wrong. The experts say this is a black and white claim. There's no gray area. And we have 17 insurance companies that represent unit owners that want to, that have filed a subrogation demand. This is a clear case of abuse of that process. this is not a subrogation claim, and we have, so if you think of 60 units damaged, and really if half of those actually have insurance, then more than half of the people that have insurance have companies that are pursuing subrogation from the association. So that just gives you a picture of how bad this has gotten, and why we need this legislation to go through, because when you get a subrogation demand as an association, we take that and we turn that into your general liability insurance company, because the subrogation demand is a third-party property damage claim. So basically, the allegation is that the association should have done something or could have done something to prevent the damage that occurred inside the unit owner's unit. And therefore, it is a liability claim because the claim is that the association damaged someone else's property.
Well, let's talk about what this legislation is before we say why we think it's needed. The legislation right now is in Senate Bill 630. It's pending right now. It's moving quite along in session. It seems to be moving forward from what I can tell. And the section regarding this issue is a very short statement, so I just figured I'd read it. The new potential change in the law provides that if a condominium association's insurance policy, an association policy, does not provide for rights of subrogation against owners, an insurance policy issued to an owner may not provide for rights of subrogation against the association. So it's sort of like a two-way street here. If we can't subrogate, meaning the association, against a unit owner, then a unit owner's policy may not provide for rights of subrogation against the association. So it would really cut off many, or if not all of these currently pending types of subrogation claims that we've been talking about, which, as Brendan mentioned, some of them are legitimate. You know, the contractor to association issue is somewhat different situation. And I'm sure there are associations who could have done more or should have done more and, you know, face these claims legitimately. But many of you out there on this webinar, and Brendan knows more than anyone probably, you know, a lot of the times these are somewhat of a nuisance claim because the amounts they're seeking and the facts that the companies are setting forth in their demands are, you know, questionable at best. And they kind of become like a nuisance action a lot of the time because they may not be really even seeking that much money in response to these claims. It could be, I've seen them as little as what, like $3,500 or $5,500, upward of substantial amounts that are talking real money. So, you know, there's a lot sort of going on right here. And in terms of the new law, you know, it could have some interesting consequences, and it's debatable, you know, whether how the market will react. What are your predictions here, Brendan? I know you feel that, you know, we got here for a reason, but what are your predictions on the consequences of this if it goes forward? Are we going to see increases for owners? Owners can't get insurance. What do you think? Because that's what I sort of hear from others, like the sky is falling. No owner will ever be able to get insurance again.
So no, I don't think that'll be the case, because when you talk about this subrogation issue, there's really only one company that's pervasive in this action, and you know there's a few others that are, you know, picking and choosing which ones they want to subrogate. But I really don't think it would impact the individual owners in getting their own unit owners policy going forward. And by the way, it's worth mentioning that the association has a waiver of subrogation. So the association's not able to do the same thing. So a unit owner does something crazy and starts a fire in their unit. Say they throw something on a candle and the sprinklers go off and they flood 5 units, which is a claim I actually had. The association's insurance company, it will pay that claim, and then they are not able to subrogate. There's a waiver of subrogation in every single policy. So it really, this comes down to fair is fair. If the association insurance company can't subrogate against an owner that causes a problem, then why should an owner's insurance company be able to subrogate against the association's insurance? And to your point, this thing started out where the amount of money that was being subrogated on a one-off case was so small that the big insurance companies that do general liability for most associations in Florida, they were just paying these because it's more expensive to get an attorney involved and actually fight the claim than it is to write a check for $5,000 here, $3,000, $10,000. Well, that emboldened some of these companies that are doing this, and it made them now subrogate just about every claim. And that's the issue. That's the problem.
So I suppose it could be that, owner policies are affected. We'll have to see whether the rates are increased on owner policies, and maybe whether rates on association policies possibly decrease because we're not having to submit those claims over, as you were mentioning. Like once the association receives this demand, receives a lawsuit, then as Brendan was explaining, then they're going to turn that over to the association carrier to deal with it. And if we don't have to do that, maybe that will decrease association insurance costs. Correct?
I do.
To be determined?
Yeah, I do feel that this is a contributing factor to why our clients and every association is seeing year-over-year increases in their general liability. So this is a contributing factor. There's other factors. There's always other factors, but this is a contributing factor. So I do agree that if this cools off with this legislation, I do feel like it will help a lot.
All right. Well, we'll see how this plays out. As I mentioned, it's moving well along in session right now. SB 630, if you want to go check that out. The subrogation language is really right at the top of this bill, so you don't have to dig through it. I think it's one of the first things that pops up if you go look this up on your own. And the effects of this, we will have to see and hopefully trust that, things become a little more equitable. I guess I will leave it at that.
Exactly.
Timely submitting claims. That's obviously a huge issue all the time. I've seen this now in 2020, 21, somewhat more than ever, some denials due to untimely submitting of claims and association insurance companies claiming prejudice. What are we talking about here, right? What are we talking about? When you have a claim, when you have a situation, your policy, your particular carrier will require you to submit that claim within a certain amount of time. There's always time limits provided by these policies. And if you don't timely submit, the insurance company will possibly respond and indicate that they've been undue prejudice, and therefore your claim will be denied because that's somewhat of an exclusion. So there's a huge, huge consequence to not timely submitting claims, but it's just like not that easy, right? I could sit here and say that and tell you have to timely submit claims, but I understand practically speaking, well, like, what does that mean? Do we have to submit every demand letter we get from an owner to Brendan and go tell him to make a claim? That seems a little over the top. So in terms of like typical reporting requirements, I know some of the policies, we can't say every policy is the same. No governing document is the same. Everything's somewhat unique, but there are sort of like typical guidelines, I suppose, that we can use here on different types of matters. I know, Brendan, that for instance, on water damage, most of the policies require certain immediate almost reporting. What are your comments there? What do they typically require?
So it is hard to get into specifics here because it does vary, but I will say that my best advice on this is to err on the side of caution. There is an art to reporting claims, and let your agent be the one to manage that. Reporting an incident to your agent doesn't necessarily mean they have to or they will report it to the insurance company. Let them discuss the situation with you and make a decision there, because once you've reported it to them, then the exposure is on us. I mean, we then will either notice the company and let them know that it's an incident only, it's a notification only, this isn't a claim, it's just something that happened. And, water damage is tricky. A lot of times if you have a $5,000 deductible, it's $1,200 worth of drywall and a $600 plumbing bill. And, the manager will call me and say, we're well under our deductible. I don't even want to turn it in. The problem is, did we get all the water? Is the water sitting behind the drywall? Is it going to turn into a mold disaster? Is it going to continue down the wall into other units? My best advice there is if you are certain that you've managed that claim and you controlled it, then I don't see any reason to turn it in. But if there's any doubt that this damage could be more pervasive than what you see, then it should be turned in, even if they feel it's going to be below the deductible. There isn't a hard and fast rule of thumb on when things must be turned in as far as timeline. But I will say, that it should be a discussion had when you're aware of the situation immediately, really.
Well, all of the policies will have their own definition of what a claim is, will
Right.
have their own time frames. So in terms of water, it typically is one that you need to deal with quickly. And Brendan is completely correct. It's sort of like a risk assessment here internal for the board. If you believe truly that this water is limited, it's below deductible, you can handle it for that type of amount. That's sort of a risk of your board. And if not, it is, probably recommended to submit it because, as Brendan mentioned, we've seen many of these turn into huge matters, which we thought were controlled at the beginning. And now somebody's claiming, $100,000 in damage. And as I mentioned at the beginning, you never submitted your claim and you want to submit it now. If you try to do so at a later time, we see all the time, the carriers try to wiggle out of these things, and not timely submitting is a pretty easy one for the carrier, I think, particularly if they haven't had time to go send somebody out, go look at it, everything's covered up. So on the property damage, it is something to get to rather quickly if you want to try to get the protection of your policy. On another sort of topic, which we see all the time, is we'll get, a demand letter from an owner sort of complaining, telling us that the board has somewhat, mismanaged funds or spent money improperly. They've breached their fiduciary duty. They, are not happy about it, and or the owner threatens legal action. So we get these like on a daily, multiple per day, across my desks on some days, not every day. But what do we do with this? If I had clients submit every demand letter as a claim, they'd not be able to get policies possibly. So, is there any suggestions to use in trying to filter through this? In terms of my own opinion, if somebody's threatening a lawsuit, they actually use the word that they're going to file something, that they are pursuing something. That makes it a little bit more concerning to me. If it's like a general complaint letter, it's less concerning. It's a very difficult determination, but we know that you are having to make these determinations, of course, with assistance of counsel, agent. What can you add to that, Brendan, on these owner demand letters?
So again, err on the side of caution, because I'm in the insurance industry, but I'm not naive to the fact that insurance companies are going to do their best to get out of a situation if they can, if you've allowed them to get out. What I mean by that is, if you get this threat of a lawsuit and you don't timely report it, you're going to get a reservation of rights letter, and they're going to allege that you've now prejudiced their case, because if they would have gotten involved from the beginning, there would have been certain opportunities, et cetera, that possibly would have allowed them to get out of a situation for less money. So it's not necessarily always the case that they're going to say, sorry, too late, you can't turn it in. It's more or less how they're going to manage the claim is the issue. We don't want a reservation of rights letter for an untimely report if we can avoid it. And they will go back and they will ask for records on a situation, and you could get a laundry list of requests from from your own insurance company. They could say, we want to see minutes from your last 5 meetings or something of that nature. And if there's something in there about that's connected to this matter, I mean, they're going to say, well, why weren't we made aware of it back then? And that's a problem.
I hear you on that, and the whole we want minutes thing. Obviously, the associations have to cooperate. That's part of your policy in terms of providing documents and timely and reasonably cooperating with your insurance adjuster. So you have to comply with all of that, and you can't bury stuff. Then you're going to get some sort of fraud issue. So you have to cooperate. You have to give all of this backup. Going back to the point of reporting sooner than later. Although the consequences of that, if you over report, I suppose that's not really a legal term here, that, we all know your premium, you're going to get a lost run, your premium will be increased. And that's been huge these days. We've seen huge increases, 70% on, associations unable to get D&O coverage with reputable carriers. So, it is sort of a balancing act there. I think as we've tried to sort of like hit home here, that not reporting could have very poor consequences. And, over reporting, it sort of is the cost of doing business as an association. It just always comes back to like, how long does it take to get yourself out? If you had 5 claims this year, you're a small association, just because, people there was a full moon and how do you get yourself out of that? It takes some time to rebuild sort of your run history. Is there anything that we can do here?
So I kind of go back to the art of managing this, and that comes down to, honestly, it comes down to the agent that you work with. And most agents do a good job with this. They're going to talk through a claim. They're going to ask the right questions. They're going to want to see an incident report, see video, see pictures, and they're going to make a professional a decision on whether this needs to be reported as a claim, as an incident, or if it doesn't have to be reported at all. Quite often, I will tell my clients, we're going to take this file and please let us know if anything else comes up related to this. But we're going to kind of like set it to the side and see if it develops into a claim, because sometimes these things, I would say half the time, certain claims just go away. And it's very frustrating to me when I start working with a new client and I look at their loss run, their loss history, and I see all of these claims with nothing paid. Because that looks horrible when I go out to the insurance marketplace and you have a 7-page loss history, even though not a dollar was paid, but you have 8 claims turned in 2 years or a year and a half, whatever it is. That looks really bad. So if we want to avoid that.
So smart board member, smart, management company manager who you're working with, reputable agent who's going to work with you and actually assist you, attorney, of course, on these, demands and matters. So you don't really over report it. You would think that we'd recommend, that route, but when you have your professionals to assist you, sometimes we can help you sort of weave in and out of it without getting deeper into the weeds, I suppose.
That's it.
All right, next topic. Here we have, let's see. The next topic is sort of a hot topic for this year and last year. This is a new product that I became aware of a couple years ago, and it sort of was thrown around a lot during COVID because we were all concerned with, associations not having coverage because of this new thing. We didn't know about this immunity bill. We thought boards were going to have a bunch of lawsuits all over the place because of, closing the pool or not closing the pool. And that's when I sort of became aware that this product existed. It's interesting. I'm going to let Brendan sort of explain what the product is, and we'll give our, 2 cents about it.
Yes, thank you. So there's two companies really. You have Atlantic Mutual, and then there's another company called Bold, BOLD. And this is a very new type of coverage. I don't think it's more than 5 years old. It's probably less. And the concept is, and this is advertised as kind of a catch-all, if you will. So you turn a claim into your insurance companies, and I say companies purposely because it could be turned into both the general liability and the directors and officers liability, and possibly even another coverage. All of those companies have to decline coverage. They all have to turn that claim down, and then that is a trigger for this legal defense policy. Now, it's important with any policy that you're informed about the way the coverage works. That's what it all comes down to. And, this is a policy that it is a good fit for some and maybe not others, but it's something that you have to understand how it works. This policy only pays the time that the attorney spends defending your case. It does not pay for any ancillary cost associated with this case. And there can be quite a few. I mean, I on one of my other monitors, I'm looking at about 20 something exclusions that they don't cover. Something as simple as depositions and trial and hiring and investigators and expert witnesses. None of that is covered.
It's only
But
attorney fees, no what we call
yeah,
costs. So it wouldn't be, as Brendan said, investigator, engineer, somebody to go out there to review what's going on, court reporter, copies, all sorts of costs are added on. This is only legal fees.
right. And of course, like anything, they're negotiated fees. So they're not, they're going to be lower fees than what you would get if you hired your own attorney. But and the attorney is assigned by the insurance company. What's most concerning to me, and I've pointed out the pros and cons, of course, to all my clients, but my concern is that there is no coverage for a settlement or indemnification or any kind of other award. Okay, so you have representation that's covered. All the other costs are not covered, but most importantly, whatever settlement is determined or award from the court or any other structure, there's no coverage for that. So if it's deemed by the courts that the association owes an individual $100,000, that comes from the association, and then they pay whatever other cost associated. There's also no coverage for appeals. So if you're not happy with that 100,000, that's now you have to go hire another attorney. And Allison, I'd be curious to what you think about that. If you have a case where you've kind of run the mill with one attorney and you're going to appeal it and you have to engage another attorney, is that something that's more difficult or more costly? I don't know.
Well, it's interesting if we get this legal defense, we're obviously the defendant here, and then we win, and the plaintiff appeals. You're saying that legal defense doesn't cover the appeal?
Correct.
That's interesting. Yeah, so that's quite a concern. So it's somewhat limited legal defense coverage. I wasn't aware of that. No. If we were the loser in the case and we had to appeal as the plaintiff now, we wouldn't be getting defense coverage anyway. We'd always have to sort of deal with that, typically speaking, at least. Right. But it is kind of concerning how it sort of stops at the first exit. You don't get any appeal coverage. And frankly, you don't really know who you're getting on this. It's interesting that it's new. We don't know the firms here, so it's somewhat of an unknown. Whether it's worth it is arguable. I don't believe these policies are that expensive. I mean, if you don't have coverage and you're going to have to go out and pay your own lawyer, I mean, at least it covers something, right? But
yeah, and I think the reason I as you stated, the reason it's become kind of a hot topic is these companies have been advertising that it's COVID coverage. I've literally seen marketing material that that they've represented that it's coverage for COVID. And because, as I hope by now we're all aware, that our typical general liability and D&O policies do not provide coverage for COVID-related allegations. So the thought is, you have somebody that alleges that they got COVID in the building or from the building, or the building could have done something to prevent them from getting COVID, which we could all argue is impossible to allege, but I've seen worse. Let's assume that type of allegation comes in. We turn that into the liability, we turn it into the D&O, and of course they say no, it's related to a virus, and we have exclusions. Then you turn this into legal defense, and they then run with it. And of course, the attorney's costs are covered, but none of those other costs that we talked about.
Yeah, so you'll have the attorney, and hopefully they will bring up this new immunity bill where associations hopefully have immunity for COVID liability unless they were grossly negligent. But that doesn't happen by magic. You have to, if you get a lawsuit, you have to have an attorney represent the association and answer it. And if you have no other coverage, this could be, cost effective for those type of purposes. And sort of, we'll see. I have clients that do have these policies that I'm sort of seeing now being implicated. So I think it should be interesting to come back in another 12 months and sort of see where this goes without the threat of COVID claims being used in sort of the sale of it and the, boosting up of these policies. We'll see.
So just last, real quick. Oh, there's the echo again.
No, you're better now.
Okay. Is it worth it? It's worth a discussion with your agent. My suggestion is, just make sure you're educated on both sides of it. I can't answer whether it's worth it. I will say that you're right. It is a very inexpensive policy. But is it worth it? It's another business decision. It needs to be looked at.
All right. Next topic here is drywall coverage and reconstruction, always a hot topic, right? We always have this as a hot topic because, I think this is what we probably receive the most inquiries concerning. I don't know about you, Brendan, but for me, this is, probably, up there at the top.
Yep.
Correct?
Oh yeah, big one.
So, and this is really for condos associations. We don't see a whole lot of drywall issues for HOAs unless you have sort of party walls, but even that's a lot more straightforward. Your governing documents are going to address that. Most time that's the owner's policy. The owner deals with it in a homeowners association. So once again, this is really about condo associations in terms of who's responsible for drywall, reconstruction, and for a condo association regarding insurance coverage, property damage coverage, the association is responsible per statute to insure all portions of the condominium property, no matter where located, replacements of like kinds and quality, except for a limited list of certain items for which the owner can insure if they choose to. So that would be, carpets, wall coverings, appliances. So very limited interior elements are not insured by the association. And associations, this has been the law for a long time, for a very long time now, since 2007, as to what the association is required to insure. But I always hear that people are shocked that it includes so much. The association condo insures against property damage, essentially like all of the condominium property, all of it, including the drywall. If there is a property damage incident, an insurable claim, the association is responsible for reconstructing the property. So that's in the event of an insurable claim here. In the event of something else, a regular maintenance issue, that's dealt with by your governing documents. If there's some maintenance issue, that's a governing document. So in terms of, oopsie, we're not at final thoughts just yet. In terms of the insurance aspect of this, the law provides that it's the association's responsibility. The law also does provide, it gives the option, which some people aren't aware of, in the event of a property damage covered type issue, that the association can allow the owner to do it based on specs, and if they give them an approval, and then we'll reimburse the owner. But that's not the general rule. It is an option, and it's really the association. but we have so many of these, and it seems kind of crazy sometimes that the association has to be so involved in the drywall issues. But for condo law, covered claims, insurable casualties, that's the way that it works. Brendan, how do you, counsel clients here? Do you have any, magic that we can use to help these issues? They're very complicated a lot of the times, and we could probably go through like 45 examples because they're all different, and we don't have time to do that today. But generally speaking, what are your thoughts on this, and how do you counsel your clients here?
So I've been licensed for 21 years, and I remember when this wasn't the case in the statute, and the statute came about for a lot of reasons, and the reason they tried to clarify this, there's a lot of good reasons, but they didn't ask me, and I wish they would have, because it should be more clear than it is. There is almost always these little nuances and these small gray areas that it's, at the end of the day, the insurance company adjuster representing the association and the insurance adjuster representing the unit owner's insurance company, they are meant to figure this out. Where things get derailed and often become a lot more difficult, and we've had a couple of questions that have come up about this, is when people choose not to purchase a unit owner's policy, which is called an HO6 policy. So when people are quote unquote self-insuring and they have damage to their unit, it becomes a little more difficult to resolve those gray area nuances within a claim because it's not done by two insurance companies. A lot of times the master policy adjuster will say, I've got this, I'll take that part. And then the adjuster for the homeowners company will say, okay, I'll take care of this part, even though the statute isn't necessarily crystal clear on who's supposed to take care of that, right?
Well, anything that the association insures is supposed to be reconstructed by the association unless the association agrees to allow an owner to do it based on specs and they give approval and they'll reimburse them. That's in a property damage casualty situation where it gets more difficult, and what we always get questions on are the owner negligently damaged something. That's where it starts
Right.
getting a little bit more confusing and where you're sort of working more together. But it does, even if an owner negligently damaged the drywall, that there was a leak from the refrigerator, right? The owners are not responsible for or not entitled to maintain, repair, replace common elements. So if the drywall is common element, it could be that, the owner damaged it, but the association's repairing it and then billing the owner back. So it's a very specific situations here that we're dealing with. And really a takeaway here is that there's a difference between when it's an insurable casualty issue and when it's not. So I think that's, something to take away from this just at a pretty basic level, because they're different analysis. And I will say, as to the HO6 policy, the law had flip-flopped on that for a long time. The statute Condo Act we're talking now specifically required it, then it didn't require it, then the association could force place it, then that was removed. And I will say, Brendan, that the statute is not, extremely clear as to whether owners are required to have it. My opinion, and I think that of many practitioners that operate in condo law, is that the statute does not require owners to have HO6 policies. But if they don't, it's they still have to reconstruct. They have to reconstruct the areas which they could have had a policy over. And a lot of associations mandate this by governing document amendments. We had a question somebody had asked, I already answered it here in the chat, that they asked if you could mandate HO6 policies through a board resolution, a rule and regulation. And my answer to that was no, that this is more appropriate for a declaration amendment. And even if you mandate it, it's practically difficult to keep on top of it. And I think that's why sort of the force placing was removed from the statute, because somebody gives you evidence of a policy, it could be canceled the next day. So it's a little bit difficult to keep on top of it and really assure your membership that everybody really is covered here.
That's right. And I agree that that the statute should, with these claims should be crystal clear. I guess some of the detail and the little nuances that come up is, there's wet drywall, but it's not that wet. The remediation company thinks they can save it. They've got 2 dehumidifiers and blowers in there, but they're also trying to save the carpet. Who pays for that? Do they split the cost? I mean, the machine is in the room. It's already doing the job for the carpet. It happens to also preserve the drywall. So there's these little things that come up that, that need to be worked out, right? And
I would agree with that. I mean, I'm very active in trying to review and deal with legislation, and I would definitely agree with that. We have seen, complexities on, moldings. What about crown molding? What about molding on the ground? I mean, these are issues that frankly aren't well addressed in the statute, and we could use some improvement there, because then we're, trying to deal with these somewhat negotiations at the last minute about a baseboard, right? So
right.
it would be nice to have some more guidance there in the statute. I know we could talk about this topic and specific examples like forever, and we're getting till the end here. So I kind of want to look at some of the questions, and we'll just pick some random ones. I see here, Diane, and we have, 5 minutes or so, even though we're running pretty close. Diane says, and this is for Brendan, why is an HOA with no claims receiving a 60% increase? I believe that's probably related to general liability. No claims, 60% increase.
It honestly, in this market, honestly, it could easily be property. And I could spend the entire amount of time that we've been together explaining this. So I'll try and keep it concise. The market right now is pure chaos. It's the worst I've seen in 21 years of doing this. And it's attributable to a lot of facts, but the reality is that, a 60% increase is on the high end, but it's unfortunately within range of what we're seeing. I would say the average is closer to 25 or 30%, but I've certainly had more than 60% in some cases. And these are, again, for associations that could be claim free. Right now, the market for general liability and property insurance, which are generally the two most expensive policies that associations buy, both of those are going up pretty significantly. So without any detail, I will tell you that it's not out of range per se, but that's kind of what's going on in the market, unfortunately.
All right, we'll take a couple more questions here. Water heaters, damage from water heaters. Is the association responsible for repair, or is the owner with the bad water heater? We hear this all the time, and this is like not a very quick one, right? But if you're an owner with a water heater that's within sort of a normal age range, you've replaced it pretty quickly and it sort of blows up. In my opinion, that's an insurable casualty type claim, and the association deals with submitting and reconstructing if it really is an insurable property damage casualty type claim. A lot of the times this comes up with an owner with a very old water heater who busts, and it's 12, 13 years old, and that is now sort of the negligence of the owner, possibly instead of a casualty claim, and maybe the financial responsibility of the owner who caused it at the end of the day. But the association is the one who is going to have to step in and deal with the damage that has now occurred, the common elements, and help this sort through. You can't just throw up your hands as an association when water is in the common elements. That's something that you will have to get involved with, whether it was related to the owner's negligence or not. And that's a very brief and somewhat oversimplistic answer.
Can I add one thing to that,
Yeah,
Alice?
of course.
This one's important. I had a $704,000 claim, and this was a unit owner who rented his unit and was told 3 times in writing that his water heater was starting to go. Basically, they said every time they got home there was water on the ground, and the owner did nothing to satisfy the situation. The association's policy has a waiver of subrogation. We talked about this. The association's insurance paid for that $704,000 claim, and they were not able to at all pursue the owner, even though they were made aware of the problem weeks in advance of the actual claim event. So that goes back to the whole subrogation problem.
Yeah, and that's when you turn to your lawyer and you say, Allison, Kaye Bender, please help us maybe file a lawsuit against this person, start some sort of action. Maybe it could be, an assessment, maybe not, depending on several factors, but you will have to do some work and possibly spend some money to recoup this money back. And sometimes if it's not significant amounts, Brendan, it comes a cost benefit analysis of whether you really want to pursue that person. If it's not worth it, it could be sort of a nuisance matter. You chalk it up to the cost of doing business. If it's a significant amount, your board better seriously consider whether that's something you want to move against the owner. But, establishing that somebody is negligent, sometimes it's difficult. You got to have backup. You have to have facts. It's not that easy. We can't just pursue cases with no backup. So I know, and I feel bad. I feel terrible a lot of the times that you feel that your hands are tied and there is no good situation here. When I just said you have to have facts, you have to have backup, just to go back to that water heater example. And Dennis, you're asking me this question, Schumann, regarding the water heater floods. Maybe you institute a rule, a policy, a declaration amendment to help establish that a water heater is, not being maintained. You have a life limit, no more than 10 years, because if they keep it more than the 10 years, maybe that helps establish that they really were negligent, they violated your documents, and it helps you recoup money if in fact it explodes and it causes damages. So you can't force an HO6 policy under current law unless your documents allow for it, but maybe you can have this board policy that would try to help you out just a little bit. We did have another question. I'll just answer quickly because this is the last one. Windows, Brendan, who covers windows in a condo? It's all portions of the condominium property that were there, and replacements of like kinds and quality. So as a general principle, no matter who maintains the windows day to day, the association's policy will be insuring them. But we do get into some interesting issues, which maybe we can come back and discuss. When owners have upgraded their windows, they've installed, windows that maybe weren't like kinds and quality. Does that take them out of the association policy and now require the owner to maintain those windows? If you have a brief answer, great. We can always come back to discuss this another time because I like this topic. Yeah,
it's a big one, but there's basically there are basically two items that are generally the unit owner's responsibility to maintain, repair, or replace versus insure. And those are the HVAC, the heating and air conditioning equipment. The association is responsible to insure that per Florida Statute 718. That's the condo statute. And the windows are the responsibility of the association to insure those, again, per Florida Statute 718. Allison's point is we have a lot of people that have upgraded their windows to impact. Generally speaking, the association's policy will cover those up to the original conveyed window type, which is generally going to be the regular glass, not impact. And then the unit owner's HO6 policy, if it's written properly, would cover the margin between the non-impact and the cost of impact. So that's the short answer.
So that's another reason why these HO6 policies, are a good idea for many reasons. Yes, 718 doesn't require them anymore, but if you're on the board, or if you're an owner out there who's upgraded your windows and you want to make sure you are paid out if we have a hurricane and they're substantially damaged here, that should be the way to go. And associations, you sometimes don't have a choice whether to allow people to replace with impact glass. And I don't think that this is something that you want to prevent. You want to move towards that, but you need association and owner needs to be aware of the predicament when you have these upgraded products. And another good topic to talk about next time. I want to thank everybody who joined us today to discuss these hot topics for association insurance. I'm interested to see how the subrogation bill goes, our legal defense insurance, how that's worked out in several of the cases I'm following, and to meet with you all again. Thank you so much, Brendan and Plastridge, for being here and sharing your expertise. We will be sending around an evaluation sheet after the course is over. Tell us if if you have any other topics that you'd like to see us cover at later webinars. I will be back here tomorrow to another webinar, the top 10 common mix-ups of associations, not insurance related. So we'll possibly see you tomorrow. Brendan, can you say your final thoughts or words here, and have a good afternoon?
Yeah, thank you, Allison. I really appreciate everybody taking the time to attend and participate. There were some specific questions that we would be glad to address, whether they're legal or insurance related, separately. And just wanted to say thank you for hosting and setting everything up, and hope to see you all soon. Thank you.
Have a wonderful afternoon. Thank you, Jeff. Thank you, Paige.
Thank you.
Thank you,
Next time.
everybody.